the protection of wide personality interest of a person, of the deceased, after death, of course. So that includes the protection of their dignity, for example, their autonomy, those very personal values, but also more narrowly the protection of their informational privacy, or as we know it, the protection of personal data post-mortem. So whatever personal data we leave behind, I argue that the deceased should have tools to control those and decide on what happens to those digital data, who has the access, who can inherit those, get value or derive some value from those data, and then how the law should change to reflect this notion of postmortem privacy. And I use the analogy of testamentary freedom in my work, amongst other things, where I argue that because of our freedom to make a will, that existed, of course, for many centuries, in a way, with testamentary freedom, allow for the extension of one's autonomy post-mortem, so one's personality aspect mostly, that is then embedded in the transmission of wealth, of things. So the argument goes to say that this autonomy could equally be embedded in some form of a control over very personal assets or personal remains of the deceased, such as personal data and their very personal accounts, such as social media or private communication.